Hey everyone, it's Joe Lines, and we're just getting ready to kick off our 34th AutoHotkey webinar, which is amazing to me. Jack and I were just chatting about it, that this is our 34th one. So we're coming up and almost doing these 3 years because we do one a month, and that's a pretty crazy number. I'm very happy that we've continued to do them, and for a while they were kind of running out of ideas. And then this great one, which is what we're doing today, my IP lawyer, Steven Thrasher, is going to be giving us an overview and helping us understand about patents and trademarks and copyrights and things like that. If I remember correctly, because we him and I chatted a bit about it, he has different sections, and if you have a particular question about the given topic, one is throw it in the chat if you like, and then either when he finishes the section or if it's spot on a very specific question to something he said and he happens to take a breath, I'll go ahead and bug him, interrupt him. But I think with the way he laid it out, we'll have plenty of time intermittently for questions, and then at the end, after the first hour, then we'll open up to just all Q&A. So let's go ahead and get going here. To start off, I'm trying to find my mouse. Here we go. The ground rules, we had 48 people register. And we know this is a global thing, right? So not everyone can attend, especially in the middle of the day. Yeah. And so a lot of people watch this later. But, you start off muted, and we do that mainly because it's mayhem when there's more than like 3 people. Even 2 is tough at times where we talk over each other. So if you have a question, use the chat, or just say in the chat, you can say, I have a question and I'd like to be unmuted. And then when we get a chance, we'll unmute you, because some questions are more complex and it's a pain to type them out. So just let us know. I wanted to give a quick reminder. So Jackie and I have been doing our podcasts. These last 2 in particular, the thoughts of what happened before you start scripting. So what do you think about before you actually pick a topic? And then the next one is the preferred order of technology of, hey, if you're going to go automate something, what do you look for first? I think if I remember correctly, Jack and I were both like, there's a COM object, that's where we start. And at the very end of the other end of the spectrum is sending keystrokes. But I think both of those podcasts were pretty interesting and could be helpful. The other one I wanted to mention is I've been reading this book, Automation Services, The Future of Work by Mary Lassithi and Leslie Wilcox. And it touches on an amazing amount of stuff that I used to do in corporate world, but they're really taking it full scale. So if you're working like with AutoHotkey and trying to take it into a business, or do it at your business, or even be a vendor, it's a really, really good book. Let me put this link in the chat right now for that one. Oh, get back, everyone. So that's a link. You can get the book. I can't say enough about it. It's an amazing book. The other thing, and let me put both of these here. This one is the podcast link, and they did a podcast based off of the book, and then they also had this deck. So these are all from the same authors, and they're different pitches on it. But I highly recommend, hey, if you don't want to buy the book, that's fine. Listen to the podcast and first get an idea if you like it and it's interesting, and work through that PDF. It's got some interesting slides in there and data on it. Now the next one, let's go in here. I'm going to do a quick overview of the script highlight. This is one, and it's kind of funny. I've been using this script myself for years. Unfortunately, it was written by Maginator, if I can say that properly, and I could only find an executable that worked. The source code, the .ahk script file, I couldn't get to launch, and so I didn't want to share it as a script highlight because I was too embarrassed to say, oh, here's the source code for this AutoHotkey program, but I can't get the script to work. Finally, I asked Maestriath to give it a look, and in like 5 minutes, he fixed it. So let me give an example here. What's great about it, and here's a GUI example. Let me bring in where's my Explorer? Oh, here. I'm still lost. I've got too many windows. Where?
Maybe you have too many screens.
Yeah, it's somewhere.
You've hidden it somewhere. Yeah.
Apparently, yeah. I'm clicking it, and it's okie dokie. Let me re-navigate to it in a different window. That is really weird. And now everyone can see my structure of what I do. And I can, of course, think under pressure. Here we go. All right. So what it's great for is if you have a bunch of files that have like a certain naming convention to them. Now watch when I start typing. So if I wanted to get rid of, this is the original, and I want to get rid of parts of that in here. Let's say if I want to get rid of text document. So see how I can type and get rid of it? It is basically stripping out what I want. So I can work in here, but I'm not going to get into all the stuff it does. It does an amazing amount of things, but it's a great script that if you're trying to rename files, you can use. This is using regular expressions or not, but it's a really powerful script that you can go through and rename files on your computer. You can also preview it, and so I can run the preview, and it would show me, let's see, the new names, show me what they're going to look like. I think there's even an undo button. Yeah, I've never tried it because you can literally see what it's going to look like. So I've never made a mistake. So I haven't had to use the undo. Actually, all right, let's do it. Now you can watch right here. Now it's done it. Now I'm curious. Oh, interesting. Oh, look at that. Oh. Okay. So it's a really cool program. It's got 8 million. It's got too much functionality to me. I don't understand all the ins and outs of it, but I will put the, oh, actually, let me get back to that. So there's a GitHub. That's this link here. And all this, you'll get emails with all this documentation as well as the deck that Steve has for just $39.95. No, kidding. And but here is a link. So I'm going to put it in the chat. This is the version that Maestriath tweaked. And so it has actually the updated .ahk file as well as all the other stuff in it. So I didn't go back and update the GitHub and say here were the tweaks. So anyway, it's in here. This one will run. So that's it. Now let's get on to here's Steve looking really pretty in his fancy picture here. Here he has information also in the back of his deck, which he's going to start here in just a minute. I had a little bit of background on him, but real quickly again. So I've been using him for a couple years now, and I was introduced by a mutual friend who's a longtime client of his, and I was really impressed both with his understanding of IP and the law, but also his well, actually there's three things: his openness and friendliness, and willing to meet with you first to talk through what you're trying to do before he starts, charging you an arm and a leg. I mean, the arm and leg comes, right? Don't get me wrong, but it's at least you can have a conversation first to make sure that like you're on the right path and which path you want to go down. Anyway, and he really knows his stuff. And the other one is just his use of technology for his business is really impressive. So, Steve, I'm going to stop sharing, and then you can go ahead and share your desktop.
Sure. Now I'm just going to go straight to sharing the PowerPoint. By the way, if you know how to share a PowerPoint in Zoom in a presentation mode, let me know. But I haven't figured that one out yet.
It opens on the other window, right, when you launch it.
Yeah, and I lose the Zoom view, so I can't see questions coming in or anything like that. So the way that this is set up right now is what I've done is I got a real quick introduction. Tell you what, I'm going to move the images so I can look this way. So there's this really quick introduction, and then the actual presentation itself is broken into 4 sections. The first section is on trademarks, the second's on copyrights, the third's on patents, and then the fourth is on trade secrets. And what this presentation is really aimed at, because it is such a high-level view, is addressing the single biggest mistake I see people make when it comes to protecting intellectual property, and that is actually waiting until they have a problem to come in and get it registered. And then in fact, that happened today. Met with a company. The competitor is using misspellings of their domain to redirect business to the competitor, clear trademark infringement. And my first question was, where's your registered trademark? And their answer was, well, we don't have one. And even if I expedite it, it's going to take 3 or 4 months to get that trademark to register to be able to enforce their trademark in federal court. There are other ways to enforce it. They're much less efficient and probably wouldn't work. So they're coming in knowing a competitor is rerouting about $1,000 worth of business a day away from them. And when I say business, I mean profit, away from them, and they can't do anything about it for probably 4 months because they've waited until after the infringement to start the protection process. By the way, if you wait more than a year with a patent, you lose it completely. So that's the single biggest mistake I see people make. And their excuse is typically, well, I didn't know where to begin. I didn't even know what kind of thing I needed to file to protect. So I'm taking away that excuse from you today. As we go through the presentation, because I've broken it up into 4 parts, when you see the part of the presentation, say on trademarks, which is first, ask your questions then. If you hold your questions until the end, and you've probably never heard this from a presenter, or at least not very often, if you hold your questions to the end, my experience is people get really confused about this stuff because we're talking about 4 different kinds of intellectual property, and there's different answers to actually the same question. For example, how long does it take for each one of these? And by waiting until the end, you're going to get confused, and the other people listening will get confused. So if you have a question about a trademark, ask it while we're covering trademarks. If you have a question about a copyright, ask when we're covering copyrights. Ditto patents, ditto trade secrets. Any questions yet?
Hey, it's awesome. It's a good plan.
All right, let's jump in. So, ground rules. This is not legal advice. This is provided as free educational material, but I hold the copyright, and Joe holds the copyright. So if you want to use this stuff, ask us first. Also, this presentation is not about what most attorneys talk about. We are taught in law school to talk about what are best practices. It's our job to scare you. It's our job to tell you the worst case that can happen, and it's our job to tell you to spend as much money as you can to keep those bad things from happening. I'm not taking that approach today. If you go talk to an attorney, they're going to give you slightly different answers than what I'm giving you, because what I'm giving you is about value. I'm putting on my business hat. In the past, if you read my bio or maybe see it on LinkedIn or some other website, you'll see I've owned everything from pet stores to juice bars to a home inspection software company that I work with to database processing companies, and one that exited by selling to Lucent Mobile that basically tied together APIs with shortcodes. I've seen lots of stuff. Oh, by the way, for some of you in the audience, I was a software programmer before I went to law school. All this to say, I'm bringing a business perspective to this presentation. I'm telling you value answers, not best practices. So don't take them as legal gospel. And so kind of leading into this, I want to make, as ground rule number 3, the concept that you got to know what you actually own, and the only way to know that is to do a search. And a search means a full search for especially patents and most especially trademarks. You can't really search copyrights, you can't really search trade secrets, but for the patents and trademarks, you need to search. I call this idea paternity testing. You got to know if these children belong to you. So that's third rule. Now, within this world of intellectual property, I also want you to keep in mind what I call the 2 big questions. Big question number 1 is, can I actually use this? Meaning, can I use it without being sued? If I choose to name my product or my company something, will I get sued for trademark infringement? If I choose to make a product or sell a product, might I be sued for patent infringement? If I choose to use a video, might I be sued for copyright infringement? So that's question number 1 on the table. Bucket number 2 of questions is, can you make this idea your own? Can you actually get it registered for protection? Can you get a registered patent? Can you get a registered trademark or copyright? trade secrets are a little bit different. Of course, we're going to cover those later. So 2 big questions. Can I use it? Question number 2, can I protect it? Bucket number 2, can I protect it? And the analysis is different for each. By the way, I've trained attorneys and worked with attorneys who've been practicing for a year or 2 who are astonished at that concept. So this sounds simple, but when you get to the application of it, it can get complex. By the way, Joe, I can't see the text right now, so if there's a question that comes in, get my attention and let me know. Thank you.
Yeah.
So with that, let's jump into trademarks. Trademarks are simply names, slogans, logos that are used to identify where a good or service comes from. Now, trademarks exist not for you as a business owner, interestingly. Trademarks exist for the consumer, to keep the consumer from being confused. Now, as it turns out, you're granted this temporary stewardship of this name, slogan, or logo by the government. And it's in your hands so you can prevent consumers from getting confused. And if people steal your customers, you're awarded the damages for that theft. That's to encourage you to keep consumers from getting confused. But if you keep that public policy in mind of it's not about rewarding you, the business owner, for coming up with a cool name, it's about protecting consumers, a lot of the confusion in trademark law falls away. And by the way, that public policy point of view is true internationally. Now, I'm going to contrast that to patents and copyrights. Patents and copyrights exist to reward inventors and creative artists, to encourage them to create more stuff. So completely different policies versus trademarks, which exist to prevent confusion. Examples of famous trademarks, of course, are McDonald's. I put down a list of food or a picture of food logos here on the screen. And you'll notice that most logos come with a name as well. Now, when logos get super famous, let's say the McDonald's Golden Arches, notice they don't even have the name McDonald's next to their logo because that Golden Arches is so famous today. But that wasn't the case 50 years ago. And so how does a trademark become famous and get so powerful? And the answer is a big advertising budget. And unlike patents and unlike copyrights, which kind of have this black-white binary existence, either you have your patent or you don't, trademarks are a little bit different. And again, keep in mind it's about preventing confusion in the mind of the consumer. Trademarks have this giant spectrum of rights and strengths based on actual consumer association of that name or logo with you, the provider of that good or service. Hope that makes sense. By the way, some slogans, because this is actually something that people will contact me about quite frequently. Hey, can I copyright a slogan? Well, actually, you can't copyright a slogan, but you may be able to trademark it. So here are some famous slogans. No rules, just right, Outback Steakhouse. Eat fresh. Any ideas, the business behind the phrase eat fresh? It's the slogan for Subway sandwiches. And then all the news that's fit to print. I picked that because it's a complete sentence. And so sometimes people will say, can I copyright or patent or trademark a sentence? And well, the answer is yes, as long as consumers associate that sentence with your business or product. All the news that's fit to print is the New York Times, is owned by the New York Times as a registered trademark. So, some facts behind trademarks. When do you file them? Well, in the United States, it's best to file a trademark as soon as you're using it. You can, again, this is the value question, and the value answer, not the best practices answer. The best practices answer is file an application before you're actually using it to reserve the right to use it and stop other people in case there's another registration, that's going to cost you 2 or 3 times as much money as doing it this way. So the best way to do this for value is to file for your trademark application as soon as you're actually using it. That can be a day or 2 after you start using it, same day. But if you file before you actually start using it, you have to submit all these extra affidavits and stuff. It takes about a week to 2 weeks to do a search, to prepare, and then to file the initial trademark application. And after it's on file, it typically takes about another 9 months to go through what's called an examination phase. There's 2 parts to an examination phase, by the way. There's the examination in the trademark office itself, and then there's an examination that occurs called an opposition phase once that trademark publishes for public opposition and inspection. That lasts 30 days by statute. It can be extended, but in your mind, think 30 days. Now, the cool thing about a trademark is that it actually lasts as long as you use it and keep the registrations renewed properly. So after it issues, you have to renew it at the 5th year, and then the 10th year, and then every 10 years after that. But as long as you keep using it, and as long as consumers, go back to that public policy, make that association between the name, slogan, and logo, and you being the person providing that service or the business that provides that service, you continue to own that trademark. Are there any questions here?
Yeah, actually, Joe Winograd asked for the name of a program. So when you give a program a name, is that a trademark or a copyright?
So would that be a computer program?
Yeah.
Yeah, that would.
I think you cut out there.
Yeah.
I'm pretty sure the answer is copyright, so I'm going to jump in real quick. But
Yeah, that would be my bet as well. You'll probably be back in a moment.
yeah. Please hold. By the way, so while he's got a little infomercial, these are 2 books that I have. Visual Hammer is really with the trademarks, and then Battle Cry is for more about the copywriting stuff and logos and slogans. His power went out. Of course,
fair enough.
The only time it would ever happen, right? Back on in a few, I think you just said.
Yeah.
What were you gonna say?
I was just going to talk to Captain Odin, who said he would say trademark, where from what I just heard from Steven, was that trademark is more like a sentence or a catchphrase. Like if I had a program named Steve, and I said always ask Steve, then it would be always ask Steve that was trademarked, and Steve that was copyrighted.
Yeah, I agree with what you're saying. Yeah, because again, there's no legal. It's not actually protecting you. It's for the consumer, right? It's and so maybe many of you don't know. I have a master's in market research. I studied brand. I study brands from the business perspective, not from the legal perspective, right? So I have a long history in brands. And I remember in my class, they talked about where brands came from. And it was, especially back before people were literate and couldn't read, they would put up pictures of things, right? And that's how people remembered, like, oh, this is where I stayed last time, because they couldn't actually read the thing, but they could recognize the picture behind it. But yeah, and I also have this other book, which, back to his point on the pretty logos and icons and whatnot.
Yeah. Can you take presenter role or something? I'm seeing a lot of very small squares on screen. Might just be me, or maybe share your screen or something, Joe.
Sure, you bet. Yeah, let me. Yeah, I'll share my screen. Okay.
Yeah.
Is that better?
Yeah, it might not be better for everybody, but to me it just seemed weird that I was looking at these very small images.
We don't need you tripping out, It's funny, it is kind of ironic, right? That like the only time something goes wrong, what law is that?
Moore's law, right?
Yeah, is when you're right in the middle of something really important. Actually, it's funny, I don't see Jean, but Jean, I helped him with a webinar on QAP, the Quick Access Pop-Up Tool written in AutoHotkey, and I was co-hosting it. It was very similar to this. My power went out, or my internet went out, and I all of a sudden he's like, Joe, Joe, and thankfully I ran downstairs and I sponged off my neighbor during the webinar. But it was with like, what are the odds?
Yeah. Okay, couldn't you have used, I don't know how much data you have on your phone, of course, but couldn't you maybe have used your mobile carrier?
My phone, I have unlimited data, and for whatever reason, because it's unlimited, I can't create a hotspot.
Oh,
yeah.
Fair enough. Yeah, we had something that they were offering unlimited data as well, but with a 50 gigabyte sharing limit. Yeah, so you could actually make hotspots, but you could only do so.
Okay, so we're back, and Steven's back, and so we had a couple questions. One was, what's the difference between the trademark, the TM versus registered trademark with the? Sure.
So, and by the way, I'm unable to share my screen right now. Also.
Okay.
So, by the way, I don't know if the last answer ever got across. Somebody asked if they could trademark a name of a computer code. If that's the name that you sell it to the consumers under or license it, then yes. So then the difference between a TM and an R. Mm-hmm. A TM is just a way of saying, I am claiming rights to this name, this logo, this slogan, but you're not stating that it's a registered trademark, and it does not actually give notice of having a registered trademark. A circle R means that your mark is actually registered by the Federal Trademark Office. And so that's the distinction between the two. Before you get the trademark registered while it's pending, use a TM. If somebody's holding off on registering for some reason, finances or otherwise, use a TM. But the caveat here, using a TM in a courtroom gets you about that much.
Yeah.
It can make you feel good, and maybe it will discourage a competitor.
That's what I was going to say, yeah.
But it's that circle R that really gives you authority and power when you get into a courtroom.
The other question we had was for the name of a program, is that something that would be a trademark or a copyright?
Yeah, if it's the name that you sell the program under, if it's something that you call it internally, then the answer is neither. If it's something that you identify as, the product that you're selling or that you're licensing, if it's the way the consumers see you, go back to that as the public policy behind the trademarks. It's all about the consumer. If the consumer recognizes that is the name that you're selling under, that's perfect thing for trademark protection.
Okay.
But it only protects the name. It doesn't protect the substance of the code, which is what we'll get to here in a little bit.
That's a great distinction. And then, do you have any sort of ballpark pricing for how much does it cost to register a trademark?
Sure. So what I have actually for all of these types of intellectual property is something I call the E5 system. So there's the E5 trademark system, and that covers education. Then you need to evaluate the mark, and then you prepare and file it. Then you go through an examination, and then you go through an enforcement period. To go from the evaluation phase through actually filing the mark, to evaluate, you're going through that search. And so the rule of thumb is for a full search and a brief review with me, it starts at $995. then to file a registration on a word mark cost another $995 for one class. And frequently I'll use the yellow pages, if you remember those things. Names can exist in each of the categories of an industry or industries. So, there used to be, a AAA plumbing and a AAA muffler and a AAA bowling alley. And of course, they're all trying to get to the front listing in the trademark yellow pages, rather. But you would never think that the same person owns all of them, even though they use the same name. The trademark system's the same way. It divides industries and services into classes. And especially when a mark is not famous or well known. By the way, a famous mark is a type of, or a strength of registration. It is a literal thing. You actually have to go to court to get declared that you're famous, so it's not cheap to do. But if you pull up that bottle of Heinz ketchup and read the back of it sometime when you're bored, it will actually say famous mark. That's literally a status. But all this to say, going back to trademarking the code, that's, yes, the name of the code is what you would trademark, but it only protects the name. And then I think I'm leaving a question hanging. Am I?
It's about the copyright. When would you actually use copyright then?
Okay, that's actually going to be the next section.
Fair enough.
So we can get to that. Did you want to jump right into copyright, or did you want to stay on trademark?
There was one more question.
I think Joe is looking for your deck here.
Yeah, I don't know if you're able to share yet, but I pulled up what you had sent to me. But Ryan had two questions. I don't know if you can see. Can you see the chat? I mean, I can read it to you, but
let me.
So they have multiple trademarks in several jurisdictions.
Okay.
And his question is, what should we say in the acknowledgement on the website? Should they reference one or more operating companies in different territories?
Usually that's done in a section of a web page called legal, where you would list privacy policies, terms of service, terms of use, trademarks used, registration numbers, patents, if your code is protected with patents that apply. It's not something you have to lead with. The circle R should put people on notice that it's their duty. It shifts the burden to people that are thinking about using a name similar to yours to go forward and actually do the research to figure out, hey, are these ideas that are these names that they can actually use? And when you say multiple jurisdictions, I'm assuming that you mean multiple different countries or areas.
Yeah, I know Ryan is international, so I'm pretty sure of the answer to that, but you can chime in here in a second. Yes.
Joe on slideshow?
Yep.
Yeah, you're fiddling with your screen on the slideshow tab.
Yep.
Yeah, you're on the view tab right now. Go to the slideshow tab. There's a use percentage. Yeah.
No, I saw your.
Oh, nice. I just saw you looking around. Sorry to interrupt with that, but yeah, a little technical. Great explanation of that.
Yep.
Yeah.
So, kind of transitioning here into copyright. And by the way, what I plan to do is go through this recording and type the Q&As and insert them as slides at the end of each section. And that's what I'd like to circulate on Friday.
Sure.
So, yeah, I'm getting a message that says that I can't start screen share.
Oh, sure. Yeah, well, that's because I was sharing my screen. So let me.
Okay, got it.
Where
I can go either way, whatever you like.
Where? No, I'm happy to. It's a lot easier if you're doing it. There you go. Now you should be able to.
Cool. Okay. So now we're going to jump into copyrights. And I'm out of PowerPoint just to try to make this go a little bit faster. Copyrights protect artistic expression, is the way that some people describe it. It's something that encourages creative people to be creative. And so if you think of things that come out of a creative community, and I have the list here: art, text, like a bestseller, but also text like software. And that's why the code is next. Three-dimensional objects, sculpture, photos, videos, music. All of these things fit in the realm of copyright. I picked some examples here. And they're selected to illustrate things. People frequently forget that copyrights apply to three-dimensional works like the Thinker, Rodin's Thinker. They also apply to derivatives. So you notice kind of up here, there's the Marley-looking guy with the dreadlocks, and then there's an altered image of his. Something that's altered is called a derivative. And the owner of a derivative of an image is actually the original owner of the original image, not the person that derived it. And so you'll see a lot of litigation and conflict in there. Now, the caveat is unless the person that did the derivative stuff had permission to use the original. So, and again, a lot of this stuff is on a spectrum. If something gets completely original, then are those changes copyright protectable? And the answer is if they're creative enough. So, you know, now we're into non-software stuff. But I like the article, Who Stole My Song? Because it's copyrightable text using copyrightable images about a copyrightable song and something derived from it. So you get a lot of different examples of copyright material right there. Within the world of copyrights, unlike trademarks that are just based on use, and when I say use, I mean trying to sell something to the public, copyrights, their magic day is a date of publication. Now, as you might expect, there are a lot of fights about what does the word published mean, but basically when you intend to get it out into the world, consider it published. At that day, go ahead and file for the copyright protection. And there are tremendous advantages in filing for copyright protection within the first 3 months of use. So you might know that with a patent, you have a year to file, and if you don't file within the year of your first use of it, then you lose the right to file anywhere. At least that's the United States rule. Europe's different. Europe, you actually have to file the application before you start using your product. Well, with copyrights, you're given this 3-month grace period, and then your rights kind of stair-step down over time. I won't go into all the complexities of that, but if you file within the first 3 months after publication, you're entitled, in the event of a lawsuit, somebody stealing your stuff, to an injunction, to a presumption that you're going to get attorney's fees, and to something called statutory damages. It eliminates about half of a trial or half of a temporary restraining order hearing, and it gives the judge a really easy way to award a dollar number to you. This is the rule that, if applied correctly by, frankly, copyright trolls, this is what they use to beat infringers over the head with, because copyright law, unlike, say, trademark law, is very favorable toward awarding attorney's fees. So for you, turn that into an advantage. File for your copyright within 3 months of publication. We'll get to the cost in a second, but I think a copyright is probably the most underutilized piece of intellectual property, especially in the software world. Basic timeline: it takes about a week to prepare a copyright application. Most of that's just back and forth with a client, making sure that the right materials are on hand and that it's going to be presented in the right way and that the correct owner is identified. Identifying the wrong owner is something that I see frequently happen in copyright applications, and correcting that mistake, same thing is true, by the way, for trademarks, will cost you about 3 to 5 times as much money as doing it right the first time, and it delays your ability to go enforce that right. I had a client come see me last August, and they acquired some trademarks through, and copyrights, but trademarks primarily through a chain of sales of franchise rights. And those documents were misfiled in the trademark office. Again, same rules apply for copyrights here. Because they were misfiled, I had to first correct the filings going back, then file the correct paperwork going forward. And even though they were being knocked off last August, it was actually March before we could start telling the people that had stolen stuff from them to stop. So do it right the first time. It pays off big time. How long does a copyright last? Your lifetime plus 70 years or 100 years for a corporation. But Disney lobbies and changes the law about every 25 years. That's just the plain truth. They were able to lobby for changes of rules in, I believe, late 60s, in the late 70s, again about the year 2000, give or take a little bit. And of course, every time the rule passes or gets updated, the copyrights get extended. Copyrights originally in the 1800s lasted 14 years, just like patents at that time. Obviously, they're completely different time frames now. Are there any questions about copyrights at this point?
So one was just, you keep mentioning, make sure you file it, but where are we filing it? Where does it happen?
Call me.
Yeah.
Technically in the Library of Congress at the U.S. Copyright Office. It is completely unaffiliated with the Trademark Office. I will also say that copyrights do go through an examination phase. The same E5 steps that apply to trademarks apply to copyrights. It's typically a much faster examination, but it's an examination no less. And if you don't respond to a rejection letter or an inquiry from the Copyright Office, your ability to push that application through gets tossed out. And if your application is tossed out and you don't respond fast enough, it's like starting all over again. And I mentioned earlier, if you file within that 3-month window, you get all these extra rights. That window goes away forever. So you got to act quick and you got to act correctly.
And so that was where I was going to chime in, Steve. We talked about this before too, but it's one of those things, you can end up doing more harm trying to do it. You're thinking, hey, I'm going to do it on the cheap. I can get this done. It's not that complicated. But it isn't just the amount of work you put into it. It's that missed time. And also possibly once you start getting out there and someone else sees it, and if they start processing it properly, right, you can really end up in a world of hurt.
Yeah, you know, I could use all kinds of examples. I actually went to law school because I tried to do my own patent and screwed it up. Over the years, I've trained over half a dozen patent attorneys, trademark attorneys, copyright attorneys. I have never seen an attorney or any other applicant submit something correct that I would let go through to the office right the first time. Rarely the second time, or the third, or the fourth. Getting this stuff right is hard because you can read the word published here on this page for the copyrights, but I doubt the audience, and in fact, I could probably do a 2-hour seminar on nuances and what the word publish means and how it's different between an architectural work, a piece of sculpture, a printed publication, a photograph, and a video. And that word alone will hang you up. So, you know, just like if you're a mechanic, if you have a car problem, you go to a mechanic. If you have a plumbing problem, you go to a plumber. If you're really big into do it yourself and clean it up yourself, more power to you. But inevitably, if you do your plumbing wrong, you might be replacing your hardwood floor, your kitchen cabinets, and your carpet and everything else in your home or apartment. Intellectual property is going to be the same way. However, if you do your plumbing wrong, you can probably rebuild your house. If you do your copyright or your patent work wrong, or even your trademark work wrong, guess what? You may lose the ability to later come in and file for your patent altogether, and you're definitely losing rights in copyright, and you're almost certainly losing rights in trademarks too. So yeah, there's a reason professionals exist for this stuff.
In the very beginning, when you started off with your story, I was trying to be good, but I've caved. I have to say this example. It was like saying, oh, hey, I had a baby. I'm going to now go and put a condom on because, I'm going to go fix the thing I did, several months ago. And it's like, it doesn't work that way. You can't just, you've already done something wrong, and man, you're going to pay for it. Right.
There you go. These are, horse out of the barn kind of problems when you try to do it yourself. And by the way, I mentioned these stories about people coming into my office and doing it wrong. I'll give you another. I had somebody come to my office. Actually, they called me and I went to theirs about a month ago. They have a product that they received a patent on, and they went through a cheap lawyer route, and so they weren't told how to use their patent. They weren't told what they needed to do to keep it alive and to make it enforceable. And they're being copied by the big names in their industry to the tune of over $100 million a year. They came to my office. I looked at what is sitting in, what they brought me, and I can't get a nickel for them. I can't even get an injunction for them because they didn't keep their patent alive the right way, and they didn't put a notice on their products. Those are easy problems to fix. And I see these kind of problems happen all the time when people try to be, to use the phrase of relatives I have in England, it's penny wise and pound foolish. And I see it all the time, and it's frankly one of the things that breaks my heart, because you see the advertisements on TV and you think, oh, this must be so easy, a child could do it. No.
Well, the problem is they can do it and they can screw it up, right? You think you're good. I think that's the real danger.
Well, when I was a kid, I remember going to my dad's office and pulling out the forms that he had. He worked with technology with AT&T, and I'd pull up his forms and I'd pull out the IBM Selectric typewriter, and I would just type junk into the blank boxes, and I would pretend like I had done something genius and put it off to the side and show my dad. And unfortunately, when you try to do your own application, and when the government takes a look at what you've got in those boxes, it will look as gibberishy to them as my IBM Selectric typewriting did to my dad back then. And it's not because you're not smart. It's just because this stuff is nuanced and confusing.
Yeah.